Good morning, everyone. Welcome to Family Mediation Week and welcome to our seminar, Children's Voices in Family Separation, with me, Elizabeth Fletcher, and my friend Helen Adam from Wales Family Mediation. We'll just wait for a minute to start because I can see there's still a lot of people joining. But I hope you can hear us okay, and you can see the start of our PowerPoint, which we'll start to go through in a moment. Okay, Helen, there's quite a lot of people here now, so I wonder if we should get started.
Thank you so much, Liz, and hello to everyone. My name's Helen Adam. I used to be a family solicitor, retrained as a family mediator in 2007, and as a child inclusive mediator in 2012. Liz, do you want to just introduce yourself?
Yeah, of course. I'm Liz Fletcher. I am a director at Family Law and Partnership. I'm a solicitor, and I'm also an accredited mediator. I should probably say I'm not a child inclusive mediator yet, as Helen is. That's very relevant to our talk this morning. But Helen and I worked with a group of people to come up with the protocol that we're going to talk you through this morning. This came as part of the Family Solutions Group and Child's Rights Matter report.
Yes, thank you. So we're here to talk about a child inclusive model to ensure that children's voices are properly heard in family separation. We seem to have processes which have evolved, certainly since the Children Act, to be child focused, which is good, but rarely are they fully child inclusive in the out of court arena. And this webinar is specifically to look at how to create a framework for children to be consulted and for their views to feed into the decision making being made by parents when cases are not in court and when they are being handled by solicitors. If you think about it, in public law, there's a clear framework for children to be consulted. In private law cases which are in court about children, in theory, CAFCAS will be consulting with children and feeding in their views and wishes into the court rulings, the court decisions. However, we know the pressures on CAFCAS, and sadly, not all children are consulted. So there's a gap there. For cases that are in mediation, there's a very clear framework for child inclusive mediation, and that is something which I know the Family Mediation Council is promoting and doing a lot of work to build up the numbers of people offering child inclusive mediation to their clients. The gap which we're looking to address in this webinar and what this protocol is about is those cases which are not in court, which are not, for whatever good reason there may be, in mediation and are being handled by solicitors. In what way can solicitors ensure that children's voices can feed into the decision making that they are supporting their clients with in inter-solicitor decision making for families who are not in court? So we're going to start by looking at what the legal framework is here. There is the the UN Convention on the Rights of Children. This was ratified by the UK in 1991. It says that children who have capable of forming their views shall be assured of the right to express those views freely in all matters affecting the child. The views of the child being given due weight in accordance with the age and maturity of the child. That is the Article 12 right. And it is an imperative. It is not the gift of the adult. It leaves no wriggle room. It says that children shall be assured of the right to express their views freely. The UNCRC has been fully adopted, Article 12 in Wales in 2011, in Scotland in 2024. Here in England, we are a little bit behind, but it is there. And Article 12 forms the basis of much of what we've been looking at on the Family Solutions Group. We also have, as legal professionals, the Family Procedure Rules, Practice Direction 12B 4.4. Children should be involved to the extent which is appropriate, given their age and understanding, in making the arrangements which affect them, and specifically in the context of dispute resolution away from the court. So that is a clear direction to all family law practitioners that children should be involved. So, as I say, for cases that are in mediation, there's a clear framework for that. But how do solicitors acting for clients bring children's voices into those decisions? How do we address that in the out of court space? And I should say at this point that the whole of the work of the Family Solutions Group is very much aimed at the out of court space. This is absolutely not about gaining evidence for proceedings. This is about supporting parents to resolve issues in a child inclusive way in the out of court space. So a clear distinction between court processes. All the direction of travel is towards greater child inclusivity. And there's a host of research that I won't go into, but it's all very clear that children want to be involved in decision making and that they are happier with arrangements. They work better. There's less parental conflict when children are involved. As I say, we have in the UK processes which are child focused, but not fully child inclusive. So this came about, this protocol, because the Family Solutions Group did some work with the UK Youth Parliament and consulted a whole load of schools and others and published the Child's Right to Matter report in 2023. And we identified this gap for children's voices to be heard in solicitor cases being handled by solicitors. And so a group of people got together, which Liz has referred to, led by Catherine Rose Pritchard and Iona Nicholson at Howard Kennedy. It was a group of experienced solicitors, mediators, and child inclusive mediators. We gathered together and put our heads together. We came up with some thoughts. We then met with the president of the family division and Mrs. Justice Knowles to talk this through. And they said very, very clearly, this needs to be managed under the clear confidentiality cloak of child inclusive mediation to ensure that children's voices can be included in decision making while wrapped around the confidentiality cloak that comes with mediation. So that is how this protocol emerged. And for those who are interested, we hosted a detailed conference on this in June 2024, 2025, in fact, time's running away, and that's available to watch on the Family Solutions Group website. So what is this? It is a process in which the child inclusive mediation is offered alongside the solicitor-led process. And there are a number of reasons, as I say, why the child inclusive mediation established framework is the one that is recommended for this. One is obviously that there is an existing clear code of practice and standards for undertaking mediation, which I'll touch on in a moment for anybody who's not clear. It enables the child to be heard and for their voice to be recognised and addressed as an adjunct to the solicitor negotiation. So it's not in place of, it is an adjunct to feed into those negotiations. And it will be obviously governed by professional standards set by the FMSB and upheld by the FMC. So I'm just going to say a tiny bit about that, because one of the pushbacks that we often get about children being consulted when parents are working with solicitors is, what's the qualification? Who are these people that are going to consult these children? There's a great deal of nervousness, quite rightly, about who children are being invited to meet. So just a tiny snapshot for anybody who's not aware. The standards are as follows. Only a mediator who is already accredited can train in CIM. We call it CIM. An attendance at a course is mandatory, which is fully assessed with written assignments. And there's obviously additional professional practice consultancy required and CPD on this, plus advanced DBS clearance required for practice. All mediators who are not trained in child inclusive mediation have to attend an awareness day so that they can explain what child inclusive mediation is to others. I should emphasize that child inclusive mediation is not therapy. And it is not a wishes and feelings report that gets written as a piece of evidence into a court process. It is simply an open conversation enabling a child to say anything that is important to them, that they want their parents to take into account when making decisions about them. It is a private family conversation, fully wrapped in confidentiality. So I'm just, yeah, onto the next slide. What is the process? At this point, I'm going to happily hand over to Liz to take you through what the exact process is. Thank you.
Before I go through that, I think it's probably an appropriate moment to, Helen's mentioned that we met with the president of the family division about this protocol, and part of his endorsement, which we have as a separate slide at the end of this talk, but it says that he has said hanging on to a practice which doesn't include children would be out of step with the court and risks practitioners being left behind. And so it really is in that context of the fact that the court process is changing and that Pathfinder is being introduced at the moment in different parts of the country, but eventually the whole country, that when the court is saying to us that we should be involving the voices of children more dramatically than perhaps has been to date, then in the private sphere, this ought to be happening too. So, first of all, how do we do this as a solicitor? So, first of all, both solicitors need to raise obviously the suggestion of child inclusive mediation with their clients, who are, of course, the parents. It's relevant to children over the age of 10, and it should be explained in the context of Pathfinder, and that the child's voices are expected to be heard even within a court process. If both parents consent, then they and their two solicitors will agree which child inclusive mediator to approach, and a list of child inclusive mediators who are obviously accredited and appropriate, as Helen has just set out, they can be found on the Family Mediation Council website. I think we can move on to the next slide, Helen. Once the parents and their solicitors have managed to agree who the child inclusive mediator should be, the child inclusive mediator will go through a process before they ever meet with the child. For the mediators listening, this will look awfully like a MIAMS, and that effectively is what it is. Because of course, these parents are not in mediation already, and so that screening process is obviously vital to be carried out. The mediator will arrange 3 initial meetings, one with each of the parents, and then a shorter one with the solicitors. When meeting with each of the parents, the mediator will have, of course, confidential freestanding meeting, just like a MIAMS would be, to find out from each of the parents directly about the family. Safeguarding, obviously vital, is done, and appropriate screening to check in and make sure that the situation is suitable to invite the child to be consulted. Of course, solicitors will have done that initial work with their clients about why this is important, but it must be appropriate concern from parents as to whether it is the right process until they've met with the mediator and feel that they're comfortable with the mediator, and they think their child, most importantly, will be comfortable with the mediator. So that's done in that first meeting. In addition, there will be, it's obviously 60, 90 minutes long, perhaps longer than a normal MIAMS. You'll go through the agreement to mediate and the SIM, really important SIM parental consent form. Helen will talk a bit more about that, but these forms need to be signed before the meeting with the child can take place. Obviously, you'll discuss about practicalities for meeting with the child, how contact is made with the child, where and when and how, and the child's particular loves and fears. I think Helen likes to bring her dogs along where possible. The mediator will ensure that the parents understand that it's an opportunity for the child to express their thoughts and feelings about the situation. but it's not about asking a child to give evidence and or making decisions or taking sides. And this is the really important difference between what would be happening in a court process where you're not gathering evidence, you're not obtaining information to use against the other parent or to create a more adversarial situation. You are putting the child at the front and center of your process to get their views and their what they want to tell their parents, or perhaps even just checking in. I've also not mentioned here that that's on the slide about the timings and manner of providing feedback. That's going to be really important both to the parents and to the child, who will want to understand, who all will want to understand how this is going to take place and how this information is going to be conveyed. Really importantly, children will not be asked to make decisions, and that responsibility remains with the parents. That will be explained to the child and it's explained to the parents. Parents must understand, that's why it's in bold, the confidentiality of the meeting with the child. And that's confidential in lots of different ways. It's confidential in the sense that it can't be used in court proceedings. It's confidential in the sense that the child chooses the nature and content of feedback to the parents. So the child might say or tell things to the mediator, but not want those things fed back to the parents. The child is in control, which is obviously totally different to the job that CAFCAS will do, where they will literally repeat everything that the child has said. The child's confidentiality is fully respected by the mediator, and the mediator will be explaining that to the child, but it's also really important that the parents understand that too. If the child wants a further meeting with the mediator, for example, how to understand what happened when the feedback was given, then that can be agreed to. I mean, obviously there's likely to be a cost impact to that, and the parents will need to all work out how they want to do that. But often I think it's difficult if a child is given information, had a session, and then it's effectively into the ether from the child's perspective. So that is something that can be discussed further. I should also say that if there was a safeguarding issue raised by the child, then that would obviously be exempt from that confidentiality and would be properly dealt with by the mediator. But hopefully, because there's been meetings with the parents already, that safeguarding would have been undertaken already. Parents must understand that feedback will be verbal only. So there's no written feedback provided unless it's requested by the child. This is really important in this because it wouldn't be in child inclusive mediation, it wouldn't be provided. And this process is an adjunct to that, which means that the information provided by the child or the views provided by the child can't ever be used in any other process. Can't, in the same way that views obtained within mediation or views generally expressed in mediation couldn't ever be transported into a court process. Once those two meetings have been done, there's a shorter video call with the solicitors, which ideally would be done together. The purpose is to put the clear professional boundaries in place, keep the solicitors in check, and make sure that they also understand that the confidentiality around the child's views. Solicitors are very well understanding of the mediation privilege, but this also extends to that because technically, of course, these parents are not in mediation. They are in a negotiated process, but they have come into the cloak of child inclusive mediation for the purposes of obtaining the views of their child. This is all set out in the parental consent form as well. Solicitors will be asked to countersign that form to emphasise their commitment to that confidentiality. And the success of this protocol, it's worth saying, it depends on the robust confidentiality being stuck to by the solicitors as well as by the parents, because if it's not stuck to, then frankly, the process doesn't work. And the children would be left having potentially expressed things that they didn't think could be used in a court setting, but then if they were ever were, then that would obviously undermine the confidence of the child, both in with professionals, but also more importantly with their parents. The only other practicality on the next slide, sorry, Helen. Before the mediator has any contact with the child, the process needs to be put in place, because any delay in providing that feedback provides a situation within a family where a child has expressed views and had a meeting with the mediator, but nobody knows what's been said or how it's moving forward. So, as in all cases, in any forum in this area, delay is never good. It's better to move things forward if possible, and that feedback is provided to parents and solicitors. So I'm now going to pass back to Helen, who's going to give her perspective as the child inclusive mediator and what's going on from her side.
So yes, thank you. So by this stage in the process, the child inclusive mediator has met the two parents, got their consent to going ahead, understood how to approach the child, also checked in with the lawyers and made sure that they're fully on board. We cannot go ahead unless we have both solicitors fully understanding the nature of confidentiality. At that point, it's time to invite the child to come and meet me. And we should make it clear for anybody who's not sure about child inclusive mediation that it is completely voluntary for a child. It is absolutely fine for a child not to reply. I used to send out written letters, but I think that feels a bit granny-ish these days, and so tend to contact children by WhatsApp. It can be very immediate. I once had a young person respond literally within a nanosecond of my WhatsApp landing. So yes, please. Yes, please. I've got lots to say. When can we meet? Others maybe don't reply if they're not interested. It is entirely voluntary for the child. That is important. In our approach to the child, we will make it clear that we're inviting them to a confidential conversation. I usually call it private. And that they can choose what, if anything, is fed back to their parents. This is where what we do with children outside of court in child inclusive mediation is fundamentally different from report writing for others to make decisions, be that in arbitration by an independent social worker or by CAFCAS for any court process. The context is different, partly because the child has complete autonomy over what is fed back. Secondly, there's nothing in writing. Thirdly, the context is we're supporting your parents to resolve issues and work things out together. There is not a context of there being a court case or an arbitration where there's polarizing positions against each other. And finally, obviously, we would never in a million years ever refer to sides. There are no sides in a family. And much of our language when meeting with children is an opportunity to reframe what may be being experienced in a way in which we're all working together to try and resolve issues. Anne Barlow and Jan Ewing are trying to change the dynamic so that they suggest that this should be an autonomy instead of parents, an autonomy of a family, recognizing the relationships within the family and a collective. Children are agents with autonomy who need to be heard as part of this decision making. Professor Anne Barlow and Dr. Jan Ewing have done fabulous research and written lots, and I'll share a link at the end to their book, Jan's book. Really commend it to everybody. But this is about giving a child autonomy within a decision making process to be heard and to have their views taken into account. So I could bang on for ages about this. We meet children sometimes face to face in person. As I say, in Tunbridge Wells, I like to bring my dogs. They always get loads of treats. They love it. Otherwise, it could be online. Quite a lot of teenagers just prefer to have an online call after school. It's all quite easy and no big stress. We try and adapt how we meet the child to make it appropriate and easy for them. It is fully confidential. I'm not here to talk about all of the wonderful things that we learn when we meet for children. I suppose the final thing I would say is that for anybody that practices as a solicitor, when you train as a mediator, it's such an eye-opener to hear the initial perspectives from the two clients. And you think, gosh, I've been seeing through glass darkly. I've only ever heard from one client, and now I'm hearing from two clients. It gives such a different perspective. I feel I can work in a different way. It's exactly the same when we bring children in and allow them a voice. I feel now that it's a bit like a three-legged stool. If we don't include or at least give a child the opportunity to be heard, we've got a two-legged stool rather than a three-legged stool. Bringing the child's voice into the process just brings a different perspective. It helps everybody see things through the child's experience. And it has a profound impact on the way in which discussions then take place between the parents. So it is absolutely totally different from report writing for contested proceedings. It's a private conversation within a family. So what happens next? I, at the end of the session with the child, will say, I've written loads and loads down, so try and capture all their words. How much of all of that are you comfortable for me to feed back to your parents? And they may say, all of it's absolutely fine. They may say, none of it. I did have that once, none of it. That was actually quite powerful feedback in itself. But often they may say, yeah, that's fine. Oh, can you not say that? Or can you say that, but say it nicely? Children love their parents. So often they want that feedback to land well, but to be heard. So we might have a bit of a chat about that. So there's specific permission from the young person in exactly what is to be fed back to the parents. They have absolute control over what is to be fed back to the parents. It is provided verbally, and usually I would want to give the feedback to parents together wherever possible. That might be on a screen together or in person together. But there may be situations, obviously there can be many good reasons why the feedback needs to be given separately. In those cases, as a child inclusive mediator, I'm very, very careful about exact words that I say so that I deliver exactly the same feedback in both those sessions with the parents separately. We would want the solicitors to be listening to this. The default position under this protocol is that solicitors are there as silent listeners to that feedback. There are a lot of reasons for this. One of them is that they hear the direct feedback through the mediator without it being filtered through the parent. Parents with absolute best intentions and because they love their children can hear things and then relay them differently. And it is invaluable for a solicitor to hear the direct feedback from the child to be fully informed then in guiding their client in the best possible way for that family situation. The bigger picture is probably what happened to me, which is that as a solicitor, I was very much trained in, I'm not trained to see children, leave it to others. If I do a good job with parents, that helps children. Once you start hearing back from children, it will transform your practice. And I think the more solicitors sit and listen to the direct feedback from children verbally, it will have an impact on the way we all practice as family law professionals. So there's a real interest on behalf of the whole profession for the solicitors to be sitting in and listening to the direct feedback. They will not speak and remain in a listening role. And as Liz has already made very clear, there will be absolutely no written feedback from that appointment. Okay, over to you, Liz.
So what do you do afterwards? Well, the parents can decide with or without their solicitors if they wish to open up the discussions within mediation with the SIM mediator following the feedback. They obviously moving into mediation is always an option for any couple, but it's perhaps particularly powerful when you've already got the SIM mediator involved for the specific role. It could be in the same session or it could be in a follow-on session. Depending on how everything evolves. The terms of the agreement to mediate would stand in any follow-on sessions because the parents have committed to that at the outset of this. However, they don't have to. If clients want to go back and move on with their solicitors and having heard the feedback, getting the insight that they need, they can have those discussions and move forward in that way. To repeat, but really important, a feedback provided can't be used in court proceedings or in open correspondence between solicitors. and it has been provided under the clear confidential boundaries of child inclusive mediation. But having it's hope that having heard that input from their child or children, that clients in whatever process, whether it's with the support of their solicitor, and there's lots of cases where that is the most appropriate, they needed the input from a child inclusive mediator for that role, but they can go back with the solicitors supported to work on whatever the particular issues are that have led them down this road in the first place. But equally, the child inclusive mediator is there if that's what's needed. It's obviously hoped that whichever road that the parents decide to go down, that it won't be a court one. But obviously that road also remains open, albeit without using the information that's been garnered from this process. As Helen's indicated already, but I think it's important to repeat that the child inclusive mediator is performing a totally different role to a CAFCAS officer who is gathering evidence, who will feed back absolutely everything that a child has said and will put it in a report. That all of that is a different role. A child inclusive mediator is coming at this in order to support a child or children, to check in with them as to their feelings in the situation that they're in, and to then support parents in providing that feedback. It's not in an evidence gathering role that they're carrying out that work. So that's the protocol. What we've now thought it would be useful to do was to share some of the messages from children who have been involved in child inclusive mediation sessions and are and have explained what the impact of that was on them. And I'll pass back to Helen for this.
Thank you. Just one thing, Liz, on the process that perhaps I didn't make clear is about the agreement to mediate. You mentioned that one of the options, if parents both want, after hearing feedback, is for them to continue to discuss issues with the child inclusive mediator in mediation. That agreement to mediate would have been shared with the clients in the initial one-to-one meeting, alongside the parent consent form, because if we see a child as an adjunct to the solicitor process, it all forms part of a mediation process. It may be that we just see the child and feedback and don't do any more. But the agreement to mediate would have to be signed at the outside alongside the parent consent form, so that it is all covered by the confidentiality cloak of a professional mediation practice. So sorry if I didn't quite make that clear. So moving on, we're going to give just a tiny few quotes from young people. And on that, I want to say something about anonymity. One of the problems of our family justice system is that it is only the cases that are in court that are reported. Meanwhile, vast numbers of families are separating and managing out of court solutions, either directly in mediation or with the help of solicitors. There is a huge amount of fabulous work going on. None of it is reported. I think all of us need to be better at providing fully anonymized stories, so that people coming into the profession and others can understand how things get resolved. So in all of these children's voices that you're going to hear, they are real children's comments in child inclusive mediation, with permission from the children to share, but fully anonymized in terms of names or anything else. It is the expression that we hear, but their anonymity, and the same for parents' quotes in a minute. All fully anonymized. These are quotes that are real. And then during the work with the UK Youth Parliament, Carly asked some of the young people at the UK Youth Parliament if they would be kind enough to read them out. So they are being read out by members of the UK Youth Parliament, but are real quotes from real young people who gave comments in child inclusive mediation. So here we go, and I need to press.
I'm waiting for life to go back to
Can you
normal,
hear that?
but it can't. I'd like to have 2 homes with a loving parents. I'd like my main home to be with my dad and to see mum. I'm quite annoyed about her going. I sort of want to be with her, but then I don't. I'm worried about what the future looks like. I can accept mum with her new man, but I can't agree with her feelings for him. She's lied to us once, so it's hard to believe her now. I've got mixed feelings about being with her and I find it confusing. I wish it could go back to how it was before. My mum has cut all communications with my dad. They just speak through lawyers. Sometimes it's through me. I do sometimes wish they could just talk, but it probably won't happen. If it's small things, it's okay to go through me, but I don't like it when there's stuff about dates and holidays and things where they don't agree and I'm stuck in the middle. They've sort of got used to it now, and it's just what happens. But I wish it wasn't like this. Christmas is the worst. Each year there's always an argument, and I end up having to go between them.
I do really like Newbury, but at the same time, I kind of want to stay near my friends in Reading. I'd like to go to school in Newbury, and they do great clubs with gymnastics and stuff. But I don't know anyone in Newbury, and I've got loads of friends here in Reading. Even the boys in my class I really like. I've got friends in every year of the school, and also in the gym club. I feel nervous going to a school with no friends. Mum and Dad are really good mates, and they speak to each other every day. I feel really comforted that they're such good friends. I guess whichever school I end up, they're going to be a drive, but they'll work out.
I'd love Granny to be friends with Dad again. Granny and Grandpa are so upset, and I'd do anything for Dad to be friends with them. It's like there's something wrong. I don't know what happened. I'd really like it if they tried at least. Even if it didn't work out, it would be good to know they tried. My favourite thing would be for us to spend Christmas together. Granny, Grandpa, and Dad, like we used to.
Liz, over to you.
Thank you, Helen. I think it's really important to remember that children are at the centre of this. So what is this process? What is it not? It's not about taking sides. It's not about leaving children to decide either. Their voices are being heard, but they are not the decision makers. And it's certainly not about finding a tool to use by one parent against the other. This is to support parents, this process. But what is it? It's a non-adversarial context, so in a very different context to that of Kafka's. We're working in a totally different way. It's fully confidential and it can't be transported into litigation. It's a totally optional opportunity for a child or children to have their voice heard, as Helen explained. Sometimes even a decision not to be heard is a decision. It's an opportunity for a child's voice to be heard within, well, proceedings is the wrong word there, and I don't know how it's ended up, because this is about a situation where parents need to work out the best situation for their child. It's an opportunity to speak to a neutral, trained third-party professional. As Helen's already set out, these are highly qualified people who are there to support children and the family. And it is a private family matter. It's not in court proceedings, and it's not that everything a child says needs to be gone over in the same way that children in a different need to have the support of social workers and other Kafka's professionals to support that family. This is not a process for them. This is a process for families who need to work out in separation the best arrangements for their children.
We're going to look at a couple of quotes from parents, but just before we do, I think there's something that Dr. Jan Ewing said in the conference last summer, which was good, which is all of us as family professionals need to really be confident, not only in Article 12 of the UNCRC, but we have the FPR, Practice Direction 12B. We need to be saying to all of our clients, Practice Direction 12B says there's an expectation that children's voices will be heard. And in our practice, this is how we do it. So it's presented as there's an expectation in the rules, the family procedure rules, that children's voices will be heard. And this is how we do it. Now, if that's what we're saying, we're not going to get such pushback. I think all of us here who are mediators on the call, and solicitors will also be familiar with this dynamic, are aware that you get those cases where parents separated a number of years ago. They've had complex, difficult arguments about arrangements with multicolored spreadsheets. They've been amended over the years, possibly even in and out of court, the child arrangements order, which is then adapted, endless years of lawyer correspondence between them, come to mediation. Children are teenagers, the mediator says, and at what point have the children been asked what their views are? And they go, no. And then you explain the family procedure rules and say, presumably your solicitor has discussed with you the expected. No. Why do we need to ask the children? We get that. That's not an uncommon case. And if we as family professionals are following the rules correctly, we shouldn't be having those cases where clients are genuinely unaware of the expectation that children's voices will be included when decisions are made which affect them. So here are a couple of quotes from parents who were very wary about child inclusive mediation. In both of these cases, they were very conflicted. They were in court for a child arrangements application. In both of them, the magistrates referred them out to hear what their children or their child's views were through child inclusive mediation. Here is the first quote.
I'll read this one out. So the father of Darcy says that getting independent, objective insight into what Darcy was thinking and how she was feeling was invaluable. Throughout the legal case, I felt as though I was hearing a lot about what other people wanted or thought was right or best, including the voice in my own head. To feel confident that we were hearing Darcy's voice, the things she didn't or couldn't say to battling parents, was not just reassuring, but actually quite moving. She was and remains the only thing that matters to me, and hearing her feedback resulted in an immediate stop to all legal action, despite my ongoing reservations. The reminder that Darcy is a people pleaser and has also enabled me since to continue open and honest conversations with her. I can now more easily identify that she is worried when she is worried about upsetting or disappointing me, and this has been such a help in our relationship.
And this is the mother of Amy. The thing is, it never seemed as if Amy's dad was interested in what she wanted. It felt like he's always wanting more, pushing for his rights, not thinking about her. Then when the mediator saw Amy and met us afterwards, he actually listened. He seemed genuinely keen to know what Amy felt and listened to what she'd said. And he agreed to go with her wishes. It was amazing. I've seen him in a different light since then, and it's been so much better. I feel we're more able to talk, and it's helped us all. And in fact, the dad in that case, Amy's dad, spoke about how he felt as though the family had been stuck in a very dark tunnel for many years and had now come out into the light. Such was the power of bringing Amy's feedback into that parent relationship. Liz.
So I talked at the beginning about what the president's view was of this protocol, and I'm just going to read out what that protocol says, which is the development of this protocol is extremely timely as it fits with Pathfinder, and it certainly fits with what the FJYPB has been saying for some years. Hanging on to a practice which doesn't include children would be out of step with the court and risks practitioners being left behind. I should just say, for those who don't know, that the FJYPB is the Family Justice Young People's Board. I think what really spoke to me with that quote when I was working with Helen to prepare this presentation was, as a solicitor, is actually that it will suddenly seem with the introduction of Pathfinder that to act without having sought and to represent your client without having sought the input of their child or children within the process will start to seem inappropriate, bordering almost on negligent, because if that is what the court process is doing, then if you're in an out of court setting, then you should be not doing what a court would do, but to follow along a similar track in the same way you wouldn't do a financial mediation without doing financial disclosure. You need to we as solicitors and mediators need to keep in mind the way that the course is going, and this is the way the course is going. So we need to do this in a sympathetic and supportive way.
So the great thing is that as a result of the hard work by Catherine Rose Pritchard and her team, is that there is a whole suite of papers all ready and approved by the judiciary and ready to be used. They're on the Family Solutions Group website. We will share the link with the Family Mediation Council so that they will also have it on their website as part of the Family Mediation Week resources. There's the protocol. There's a sheet of frequently asked questions, which is useful either for solicitors who aren't quite sure what this is all about, but also to share with the clients. Then there's the all-important parent consent form. As I say, the mediator would have their own agreement to mediate, which would be alongside that. And then just a helpful sheet of practical tips for encouraging parents. Parents are very wary. And, they need to be reassured what this is. So there's Jan Ewing is very clear that children want to be consulted, that the law is clear around it. There's an expectation. Article 12, there's also the FPR, there's also the FMC Code of Conduct, Rule 6. So it's there in all the professional rules. But parents are wary, solicitors are wary. Adults tend to be the gatekeepers for why children are not routinely included when decisions are made which affect them. So here are the suite of documents. There's a QR code which should take you straight there. Otherwise, if you can't see the QR code, go straight to the Family Solutions Group website. It's just familysolutionsgroup.co.uk, and there's a drop-down menu, Children's Voices in Family Separation, and it's all there